Welcome everyone to Lamparello Law, Education, and Advocacy. You can find us at lamparello-law.com. I'm Adam Lamparello, and our firm assists clients with navigating the legal process to protect their civil rights and civil liberties. Today we're going to discuss the 10 tips on how to deal with an investigation. What should you do when you're being investigated to maximize your chances of success? So let's get straight to tip number one. You have to stay calm. You cannot let your emotions get the best of you. So many times when people are noticed that they are being investigated, they get nervous. They suffer so much anxiety. Am I going to get fired? Am I going to go to prison? What's going to happen? And those emotions can lead to very impulsive decisions that hurt your situation tremendously, such as firing off emotional emails, talking to people you shouldn't talk to. The first rule you have to abide by is stay calm and do not get emotional. The second tip is you have to read the notice carefully. Again, you have to read the notice carefully. What is being investigated? Who's investigating you? Why are they investigating you? What are the allegations against you? The reason that you have to read the notice carefully is first to know the procedures that you're going to face, the allegations that are being made, and the preparation that you're going to need to do to fight those allegations. Okay? So read that notice carefully. The third tip, and this is an important one, you have to preserve everything. Okay? That means preserve all emails, any documents, screenshots, anything that will provide a factual basis for you to rebut the allegations. Because oftentimes in investigations, it's he said, she said. The best way to win is to show objective, factual evidence that corroborates or supports your version of the events. Tip number 4, and this again is also an important one. Don't discuss the investigation casually with other people, whether it's friends, colleagues, or supervisors, no matter how much you think you're right or how much you think you've been falsely accused. Whatever you say to anyone else becomes part of the record potentially. Okay? Don't trust that whoever you talk to is going to keep your communication confidential. So avoid talking to people, texting people, calling people, emailing people. Okay? You may think you can trust them, but they may go and they may tell other people, and their version of what you told them may differ and materially harm you. So, to put it bluntly, don't say anything. All right, the fifth tip, you have to read and know very well the governing policies of the organization conducting the investigation, because those policies will be the standards by which they determine if you are responsible or not. Okay? So you have to know those standards because you can't form a defense unless you know the standard by which they're going to make a determination. So familiarize yourself with them. That is critical if you're going to be not only adequately prepared, but could present the best defense possible. The sixth tip, you should build a timeline, okay, of the events in question. One of the most important things that you can show an investigator is objective facts that also establish a timeline of when things happened, because then it makes it incredibly difficult for an opposing party to dispute that. That's why documentation is so important for corroboration, and part of that is establishing a airtight timeline. Now, the seventh tip is in many investigations, you will be asked to provide a written statement. That's pretty ordinary. Before you provide that written statement, you need to think, you need to reflect, and you need to be strategic. It's not as simple as, oh, I'm just going to tell my side of the story and that's it. Because it's not just what you say, it's how you say it. So you need to step back and think, what is the best way for me to present this narrative in written form? That may entail acknowledging weaknesses in your situation or fault that you may be responsible in some way for the incident. You may not be, but address weaknesses in your case, okay, because that enhances your credibility. It may include emphasizing certain facts over others, eliminating irrelevant facts, eliminating unnecessary explanation, creating a theme that runs throughout your statement, where best to place and emphasize certain evidence and certain facts. So before you provide a written statement, you need to go through the process of thinking about that. And then when you write it, you need to step back, take some time to think about it, and rewrite it until it's in a form that maximizes the persuasive value of the argument you're making. Okay? Now, what's the eighth tip? The eighth tip is very, very important. You've got to identify who the decision makers are. Because when you're arguing a case or making a statement before an investigator, one of the most important things to remember is that you have to know your audience. You have to know who you are talking to and put yourself in their shoes and try to see the situation from their perspective. Okay? Most people say, I didn't do it, I was falsely accused, the investigator will see the truth. Not necessarily true. You have to determine who is making this determination. How do they think? What is their perspective? Because that will inform how you present your case in written and oral form. For example, what are the weaknesses that the investigator is most likely to focus on? If I was in the investigator's shoes, what questions would I have for me? You have to think not only as an advocate, but you have to think as the investigator and really interrogate your position so that you can identify weaknesses and respond to them effectively. Now, the 10th tip, probably the most important tip of all of them. You have to focus on credibility, okay? You have to be believable. Like I said before, it's not just what you say, it's how you say it, okay? The investigator has to believe you. So it doesn't matter how strong your facts are. If you don't say them convincingly, if you don't say them with confidence, if you're not very well prepared, you are going to lose credibility. If you are not honest and acknowledge weaknesses in your case, you will lose credibility. If you over-explain, you will lose credibility. If you don't listen to the questions being asked of you and respond directly to those questions and give no more information than needed, you will lose credibility. That's why the strongest cases and people who are in fact innocent are found guilty or responsible if it's a non-criminal investigation. Okay? Your credibility is everything. That's why you have to practice and practice and practice, both in what you write and how you say it, because your credibility will often be the determining factor in whether you're found responsible or not. So I hope these tips have helped you. We are going to continue on a daily basis to provide many videos on various legal topics that are going to help you navigate the legal process and to best protect your civil rights and civil liberties. If you like this video, please hit that like and subscribe button, and we'll see you soon with another video. Take care.